They can revoke your green card. Know your rights. A lawful permanent resident card, or green card, is one of the most valuable documents an immigrant can hold in the United States. It represents stability, opportunity, and the right to live permanently in the country. However, what many people do not realize is that this status can, under certain legal circumstances, be revoked. Today's video explains the specific conditions under which the U.S. government can revoke a green card, the legal framework behind those decisions, and most importantly, the rights and protections available to permanent residents. Understanding the legal foundation. The authority to revoke permanent resident status is not new. It is clearly defined in the Immigration and Nationality Act, INA, Section 237, which outlines all situations in which a lawful permanent resident may be considered removable from the United States. A green card is not a visa or a temporary permit. It is legal evidence that the United States is your permanent home. As such, it carries both privileges and responsibilities. The government cannot arbitrarily take it away. Any attempt to revoke a green card must be based on clear, lawful grounds supported by evidence and due process. Importantly, every green card holder has the right to defend themselves in immigration court before any final decision is made. This ensures that revocation is not automatic and that lawful residents are protected by the same principles of fairness that apply across the legal system. Abandonment of residency. One of the most common reasons for losing permanent resident status is abandonment of residency. This occurs when a green card holder spends long periods outside the United States without maintaining meaningful ties to the country. If you remain abroad for more than 1 year without obtaining a re-entry permit, the U.S. government may presume that you have abandoned your residency. However, this is only a presumption, not an automatic loss of status. You have the right to explain the reasons for your absence. Medical treatment, family emergencies, or temporary overseas work assignments are valid explanations if you can demonstrate that your intention was always to return to the United States. When evaluating abandonment, immigration officers and judges look at practical evidence, whether you maintained a U.S. address, filed federal tax returns, kept local bank accounts, or preserved family and employment connections. Strong proof of ongoing ties can help protect your green card from being considered abandoned. The I-407 form and airport inspections. A critical moment for many permanent residents occurs at the airport. Green card holders returning from extended trips abroad are sometimes asked to sign Form I-407, known as the Record of Abandonment of Lawful Permanent Resident Status. Once signed, this document officially records that you are voluntarily giving up your green card. Many travelers sign it without fully understanding the consequences, believing that it is mandatory. It is not. If you are ever asked to sign Form I-407, you have the right to decline and request to appear before an immigration judge instead. The judge can review your situation, hear your explanation, and determine whether abandonment truly occurred. You also have the right to remain silent, request legal counsel, and avoid signing any document until you understand its implications. A short delay at the airport is far better than unintentionally surrendering your permanent status. Fraud and misrepresentation. Another reason a green card can be revoked is fraud or misrepresentation. This typically occurs when false information was provided, intentionally or otherwise, during the immigration process. Common examples include inaccuracies in marriage-based petitions, family relationships, or background information. For instance, if a person married before receiving a green card but did not disclose it, or if they misstated their age or marital status, the government may later determine that they obtained residency through misrepresentation. However, not all mistakes amount to fraud. The law requires proof that the individual knowingly and willfully provided false information about a material fact, meaning something that affected the decision to grant immigration benefits. Simple clerical errors or minor inconsistencies generally do not qualify. Still, any potential discrepancy should be reviewed carefully with an immigration attorney before filing new applications such as citizenship. Criminal convictions and deportability. Even after obtaining a green card, certain criminal convictions can make a person deportable under immigration law. Section 237 of the INA lists specific categories of crimes that can lead to removal. These include aggravated felonies, crimes involving moral turpitude, drug-related offenses, and crimes involving domestic violence. What makes this area complex is that immigration law defines these terms differently from state criminal law. A conviction that appears minor under state law may still carry serious immigration consequences. For example, a theft offense with a 1-year sentence, even if reduced or partially served, can be treated as an aggravated felony for immigration purposes. Likewise, possession of a controlled substance, even if punished only by probation, can lead to deportation. For this reason, any green card holder charged with a crime should always consult an immigration lawyer before accepting a plea agreement. Criminal and immigration law operate independently, and the outcome of one can significantly affect the other. Material support to terrorist organizations. Another complex area of immigration law concerns providing material support to terrorist organizations. The term material support is defined broadly and can include money, goods, services, or even participation in community events connected to an organization later designated as a terrorist group. There have been instances where individuals faced immigration consequences for activities that occurred years before a group was officially added to the U.S. terrorism list. Because of the wide scope of this definition, anyone involved with overseas charities, religious organizations, or political groups should exercise caution and seek professional legal advice before traveling or filing new immigration applications. If the government challenges your status. If you receive a notice to appear in immigration court or are informed that your permanent resident status is being challenged, you still have substantial legal rights. You are entitled to a full hearing before an immigration judge. During that process, you may be represented by an attorney, present your own evidence, call witnesses, and cross-examine government officials. Even if the government proves that grounds for removal exist, relief options may still be available. These include cancellation of removal, adjustment of status, or certain waivers depending on your individual record, duration of residence, and family circumstances. It is important to understand that being placed in immigration court does not automatically mean deportation. It is your opportunity to defend your case, clarify misunderstandings, and present the evidence necessary to retain your permanent resident status. How to protect your green card. Maintaining permanent residency is largely about consistency and documentation. The following habits significantly reduce your risk of problems. Live primarily in the United States and treat it as your true home. File U.S. federal tax returns every year, even if you are temporarily working or living abroad. Maintain a U.S. address, bank account, and phone number that remain active. Avoid long trips outside the country, and if extended travel is necessary, obtain a re-entry permit in advance. Keep copies of leases, pay stubs, tax records, and utility bills, all of which demonstrate continuous residence. Always be truthful on immigration forms and during interviews. If a past application contains an error or omission, consult an immigration attorney to correct it properly rather than ignoring it. Finally, if you have any criminal history or complex travel patterns, seek an immigration review before filing for U.S. citizenship. Preventive legal advice is far more effective than reacting to a problem after it arises. Consider applying for U.S. citizenship. For those who meet the eligibility criteria, becoming a U.S. citizen is the strongest protection available. Once naturalized, you cannot lose your status or be deported, except in very rare cases involving proven fraud during the naturalization process itself. Citizenship provides long-term peace of mind, greater security, and full access to the rights and responsibilities of American life. For many permanent residents, it is the final and most stable step in their immigration journey. Final thoughts. A green card is not fragile, but it is not absolute either. The government can only revoke it for clear, legally defined reasons, and every permanent resident has the right to challenge those reasons in court. By maintaining strong ties to the United States, staying compliant with tax and residency requirements, and seeking professional advice when needed, you can protect your status and your future. In immigration law, knowledge truly is protection. Understanding your rights allows you to act with confidence and preserve the life you have built in America. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, and see you in the next video.